We have to talk about a decision by United States District Court Judge Miranda, an appointee to the federal bench by President Barack Obama, who set forth a series of findings of fact in response to a demand from the United States Court of Appeals for the Ninth Circuit in a case involving the ban on unserialized firearms, banning the possession of unserialized firearms in the state of Nevada. Let's break down some of the analysis, or really, in many respects, the lack thereof, by Judge Duped. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Israel Disarmed, What the 10/7 Attacks on Israel by Hamas Teach We, the Americans, about the right to bear arms. Check it out on Amazon. All right, folks, so we have to talk about this decision in a case involving the Firearms Policy Coalition, Roger Palmer versus Stephen Sisolak. This is a Second Amendment challenge brought against a Nevada state law that bans the possession of unserialized firearms. And this is a case that had been brought several years ago. It was lost on multiple occasions in the federal district courts out there. No shock, that's Nevada's part of the Ninth Circuit Court of Appeals. Went up to the Ninth Circuit. All sorts of things happened, of course. And bottom line is this. After Bruin, the Ninth Circuit sent this case back to the United States District Court for the District of Nevada, where the case began, with instructions that a federal district court judge, Judge Miranda, enter a series of findings of fact involving history and other information that the Ninth Circuit wanted her to find or figure out, and then send back up to them so that the United States Court of Appeals could then do what they needed to do. Now, the reality of what happened here, and then we're going to get in and break down this opinion, this findings of fact opinion by Judge Duped in just a moment. But what really was going on here, and we're going to find out if this anti-gun strategy worked tremendously or not at all. This was part of the ongoing attempt to delay getting any additional Second Amendment cases to the United States Supreme Court on any other issue other than like the Rahimi case, where you had a terrible party, Mr. Rahimi, with a terrible record, in an attempt for the anti-gunners to try to destroy the Bruin methodology and destroy Heller. And of course, this delay tactic by the anti-gunners and anti-gun judges will only be successful if Donald Trump is not reelected president. Because this delay strategy presumes that either Kamala Harris / Joe Biden continues for another 4 years. And if that were to occur, then the idea was that the Supreme Court composition would change, with likely Justice Thomas or Justice Alito being replaced by some liberal justice like another Justice Brown Jackson, who will just rubber stamp any gun control law, period, full stop, which is exactly what would happen. But again, if Donald Trump becomes the next president of the United States, the 47th president of the United States, then that delay tactic will be no good, because even if you swap out Clarence Thomas or Sam Alito for another judge, you will be doing it for, some other rock-solid originalist conservative, and all you'll do is really get a younger version of Thomas or Alito, is my guess, and this will not do any good for the anti-gun movement in the United States. So with that said, and the fact that this was a delay tactic, the United States Court of Appeals for the Ninth Circuit, rather than deciding the question of whether or not unserialized firearms can be banned under the Second Amendment, which is a legal question. Hear what I just said? It's a legal question. Instead, they wanted to buy time and delay things, hoping that this composition of the Supreme Court would change in a favorable way. So they sent the Palmer versus Sisolak case back to the United States District Court in the District of Nevada to Judge Duped. And Judge Duped then, of course, went about spending a whole bunch of time engaging in normal discovery and other things that are really more appropriate for commercial cases and not appropriate for Second Amendment cases. But nevertheless, keep in mind the big picture. This is all a delay tactic by the anti-gunners and the judges that don't like the Second Amendment, looking to buy time. Now, with that said, Judge Duped, being a district court judge, was instructed by the Ninth Circuit Court of Appeals to engage in a set of findings of fact and historical findings, which was her job to do once she was told to do so, and she went ahead and did it. So let's now turn our attention to Judge Duped and the decision that she issued. I'll put a link to it down below. And this is where Judge Duped goes off the rails pretty clearly. Because, remember, You start with the text of the Second Amendment. If it's implicated by a modern-day gun control law, the burden shifts to the government to do what? To show there is a long-standing, going back to the founding, 1791, a long-standing tradition, a historical tradition of a firearms regulation that is analogous to the challenged regulation being fought about in court today. Now, if you're dealing with a ban in 2024 of unserialized firearms, the only way that's justified is if you can go back to the founding of America to try to find analogous laws where unserialized firearms were somehow banned or regulated in any respect. And that is simply not doable. Because at the time of the founding, the technology, and listen carefully to this bit of history, it's very important to understand this and very helpful. If you go back to the founding, the technology existed to have firearms. The technology existed to make your own firearms, and the court here actually indicates that that was typical at the time of the founding. And this is very important, what I'm about to say. The technology existed to serialize firearms at the time of the founding, or to mark firearms. How do we know this? Because at the time of the founding, you had private militias and other militias. But you had militias, including a militia formed in Virginia by none other than George Washington. Now, why is the formation of these private militias relevant to today's fights over unserialized firearm bans? It's quite simple. At the time of the founding, the private militias like George Washington and these others who had militias would often go out and buy weapons and firearms for the militia. And then, as appropriate, they would take the firearms that the militia owned and loan those out to the members of the militia sometimes, to ensure that those weapons were returned by the militiamen back to the militia, back to the organized militia. Those firearms were marked with letters and numbers, so that when I gave out a firearm, GW 5555 to Bob to go fight, I want to get that weapon back, because that weapon doesn't belong to Bob. That weapon belonged to me or George Washington. And the way to track getting the gun back with your list of who got what, you would ask Bob, please give me back the gun I loaned you for militia services now that you're moving on, and I'm now going to loan it to Lenny. You see? Now, the reason why this is so important to understand is, if at the time of the founding you had firearms, obviously, you had people making their own firearms, obviously, even Judge Duped even admits this, and you had the technology available to serialize or mark firearms, but here's the key: the government, the states, the federal government never, ever required that people mark or serialize their firearms at the time of the founding. Did you hear what I just said? There are no laws, no regulations by government at the time of the founding, either at the state level or the federal level, mandating or requiring that Americans serialize or otherwise mark their firearms, despite the fact that that technology was available, such that if the government wanted to force everyone to serialize their guns, they could have done it because the technology existed. Now, does anything that I just say appear in Judge Duped's opinion? Not that I can find. Instead, she doesn't understand that you cannot have a historical tradition of regulations if you do not first and foremost have regulations from which to draw conclusions. It's induction. It's inductive logic. You have to have examples in a data set that are analogous to each other, similar to each other, and then you look at them and then you draw a conclusion and form a conclusion. So instead, Judge Duped here talks all about all sorts of other regulations at the time of the founding we've talked about in the past. She talks about regulations on carriage. She talks about regulations on this and regulations on, denying Catholics the guns. Talks about regulations on, people that weren't loyal to the patriot cause being able to be disarmed and all sorts of nonsense like this. Then she talks about late 19th century stuff after the Civil War. And then she talks about 20th century historical laws. There was no serialization requirement by the government in the United States until sometime in the 20th century. And the United States Supreme Court has already said that 20th century laws are too late in time to give rise to a historical tradition of firearms regulations that can serve as an effective exception to the text of the Second Amendment. Does Judge Duped say anything about this? No, she doesn't. All she does, and here's where she goes off the rails in particular, and this is where she's confused, and a lot of district court judges are confused by this or they don't like it. This is where she gets confused by the fact that she is allowed to make findings of fact, but findings of fact are supposed to be about the parties as a general matter, the plaintiffs, the defendants, and whatnot. She went out there and was trying to make findings of fact about laws, but facts and laws are not the same. Finding laws to give rise to a historical tradition of laws involving firearms requires a review of laws. Instead, she relies on an expert proffered by the government defendants that says all sorts of things about American law and history. But experts are not needed to articulate the law. Why is that? Because the law is supposed to be figured out by the lawyers and the judges. They're the lawgivers, not some expert. Again, if you want to talk about historians and historical experts, you don't need to do it in a Second Amendment case. You don't have to believe me, by the way. Ask yourself the following question. And Judge Duped should have asked herself this question, but you can see when she's confused the way she wrote this opinion, saying she's confused why the plaintiffs, the Second Amendment plaintiffs, did not put on all this evidence and bragged and basically said how wonderful it was the defendant put on this evidence, not understanding that the Second Amendment plaintiffs have no duty to put on this evidence, and the defendant's evidence is really not evidence because the only thing that matters is the historical laws. This other stuff is nice, but really not important. But in fairness to Judge Duped, to some degree, she was kind of commanded to do this by the Ninth Circuit. So to some degree, she had to do some of this because she was directed to do so by a superior court. So with that said, ask yourself the following question, a question Judge Duped should have asked herself. How many testifying historical experts were used in Heller? 0. How many testifying historical experts and historians were used about regulations of firearms in McDonald? 0. How many historical experts and historians were used by the Supreme Court, testifying experts in Catano? That's 0. How many testifying experts were used about the Second Amendment and historical regulations involving firearms in Bruin? The answer is 0. And how many historical testifying experts were used to speak on the issue of the Second Amendment in the Rahimi case? The answer also is 0. So how is it possible? Please explain this to me, Judge Duped, out there in Nevada. How is it possible that the United States Supreme Court, the Supreme Court of the land, the giver of law to inferior judges like yourself, inferior courts under Article 3 like yourself and your court, how is it that they are able to decide Second Amendment cases without the need of a historian or historical testifying expert or any testifying expert in no fewer than 5 different 21st century Second Amendment cases? And somehow you decide you want to go out there and give all this credibility and embrace the findings of fact and historical record of an expert. What makes you special, Judge Duped, over and above the United States Supreme Court? Or perhaps you should look in the mirror and ask yourself, well, if the United States Supreme Court's not using testifying experts to lay out the law and the history, maybe I shouldn't be doing it either, since I'm an inferior court judge under Article 3, and they're the superior Supreme Court, and I'm supposed to follow their law and their guidance and their precedents and their methodologies and their interpretations. Maybe I've done something wrong. Just food for thought. So with that said, what's going to happen here is, of course, this is going back to the United States Court of Appeals for the Ninth Circuit. The Ninth Circuit will inevitably mess this up one way or another. Even if the panel gets it right, it will be en banc, as we know. It will take 18 months to 2 years before the Ninth Circuit issues a ruling in this case of Palmer versus Sisolak, dealing with the unserialized firearm ban in the state of Nevada. And then we'll see what the U.S. Supreme Court does. And of course, the most important factor for the Second Amendment movement right now, right here and right now, is for Donald Trump to be elected the 57th President of the United States and for the United States Senate to be controlled by Republicans. So that Donald Trump can nominate appropriate Supreme Court justices and federal judges, and the Republican Senate can sign off and confirm them. That is what has to happen here. If that occurs, then the delay tactics of the anti-gunners and their anti-gun handmaidens in the federal courts will not have paid off. That gamble will not have worked because they will not get a better composition of the U.S. Supreme Court by the delay. They will get more of the same, and that will be very good for the Second Amendment. All right, folks, so there you have it. Hope you learned something here today at the 4 Boxes Diner. Make sure you follow me on X at 4 Boxes Diner. Don't forget to subscribe to this channel. We're trying hard to get to 200,000 subscribers. We're very far behind all the other channels in the Second Amendment space, but we're working hard to try to catch up. And make sure you like this video, and feel free to share it with your friends on social media. I'm not very good at social media, so I'd appreciate the support. And I look forward to seeing you all again here at the 4 Boxes Diner.
Orders up. Table 2A.